Chairman, and again, I join with everybody else, Mr. Horowitz, for thanking you and your team for the work that you have done here. I'm going to go back to an issue that's been talked about by many of my colleagues today, and that is this question of bias. And actually, I want to start by going back to June of 2018, when you were last here before the committee. And when I asked questions of you at that time, I talked about your findings then with regard to bias. The specific focus that I recall there was Peter Strzok and Lisa Page, and the information that's already been well presented here about what I consider to be the undeniable bias that they had against the President Trump. At that time, you made similar statements to those you made today, which is that you did not find bias in the decisions that you were evaluating in that report. But as I went through that with you, I think that you also confirmed that you were not saying that there was no bias by those who were involved in making decisions. Rather, you were saying you could not prove that that bias was a factor in their management of the activities they engaged in on behalf of the FBI. As I understood it, you said that there was bias, but in fact that you had asked them whether their bias influenced their work performance. They had told you that it did not, and you had no contrary evidence to dispute that. Is that correct?
Let me clarify. Let me explain. We found that those text messages evidenced bias, and what we ultimately found was that other people were involved and made many of those decisions, not them. And that was the base, not because we didn't know whether they were biased. Those texts evidenced bias by them.
All right.
The question was the other individuals who we didn't have text messages for, otherwise evidence of bias by those individuals.
And that would be consistent with what your report here today says. As I'm reading from the executive summary, Deputy Attorney General, I believe that's his title, Priestap.
Assistant Director or Deputy Assistant Director, depending upon the time period.
He's the one who made the final decision to open each of the 4 investigations.
Correct.
He did that in consultation with a number of others, including Peter Strzok.
Correct.
And you don't necessarily know what advice was given in those conversations, do you?
I don't.
But he made the final decision, and because you had and you've used the phrase very consistently here today, you did not find documentary or testimonial evidence that political bias or improper motivation influenced the decision to open these 4 investigations.
Right.
Did you ask Mr. Priestap whether he had bias?
We asked all the witnesses, not just him, as to whether bias or other improper considerations had any impact. But we also looked for emails, text messages, documents that could show what we found, frankly, was Strzok and Page. I mean, if that is how you find evidence of bias. Now, beyond that, I'm stuck trying to understand what's in somebody's head if there's no other.
I just want to make it really clear what it is you are saying and what you are not saying.
Correct.
And in this case, what you're saying is that you could not find any documentary or testimonial evidence to contradict the statements of the investigators that they were not letting bias influence their decision.
Correct.
Do you believe that's an open question? I mean,
I can only speak to the evidence we found. I think the important point here, and I made earlier, is all the evidence is here. People are free to consider, evaluate what they think ultimately people's motivations were. We don't reach a definitive conclusion.
You aren't making that decision.
We're not making a decision on ultimately information, evidence we don't have that somebody may have acted.
But there's, in my opinion, and I think in the opinion of most of us who have, on this side of the aisle at least, who have talked to you today, I think there's tons of evidence of bias here. In fact, you have referred for further action to the Attorney General, one case for criminal prosecution, if I understand it right, and other cases of how many other individuals?
So, but I want to be clear, we're talking now about the FISA as opposed to the opening.
I understand, and there is a distinction between the opening of the
very significant distinction
and the conduct of the investigation.
Correct.
And so I'm moving, I understand that. In fact, I appreciate
I've tried
your
to
making
separate
that
those two.
clarification. Because in the conduct of the investigation, it appears to me there has been intense bias. But you're not making that judgment. I understand that. You're referring that to the Attorney General, correct?
And the FBI for adjudication,
And the
consideration of
FBI,
this.
understood. And I
How to-
believe in response to Senator Ernst's question on this same issue, you indicated that similarly, since you could not find any documentary evidence or testimonial evidence to contradict their statements that they were not biased, that leaves an open question as to what the FBI or the Attorney General will find with these referrals.
There are significant serious failures here on the operation of the, particularly in connection with the FISAs, whether it was sheer gross incompetence that led to this versus intentional misconduct and what the anything in between, and what the motivations are. I can't tell you.
You're
as I
not
sit here
making
today.
that decision.
I can't tell you as I sit here today because I don't have enough evidence to reach a conclusion.
But if someone were to characterize what you are telling us to be that you're telling us there is no bias here, that's not what you're telling us.
That is not as to the operation of these FISAs what I'm telling you.
All right, understood. And I did want to get to this question, though, about the operation of the FISAs. And again, you may not answer this, and that's fine. But it seems to me that if we go beyond the bias question to intentional versus grossly negligent, it seems to me that the kind of misconduct that has been presented by you and reviewed by our chairman and many others here today is mind-numbing to consider that it could be just accidental. Can you reach a conclusion like that?
I'd be skeptical, but I understand why people would be skeptical of that. There is such a range of conduct here that is inexplicable, and the answers we got were not satisfactory, that we're left trying to understand how could all these errors have occurred over a 9-month period or so among 3 teams, handpicked, one of the highest profile, if not the highest profile case in the FBI, going to the very top of the organization involving a presidential campaign.
Well, I understand that. I appreciate that. I think it is explicable. But I understand that you can't, or at least aren't, going to make that jump. You are going to refer these cases. And I appreciate that. Is criminal prosecution a possible action in the cases other than the one you've specifically referred?
I wouldn't want to prejudice or prejudge anything. I'd leave it to the department to speak to you on that.
All right. Let me go on for just a moment. Let's move to the whistleblower question just once more. I'm shifting topics completely. It's come up several times today, and I understand your point that a whistleblower is entitled to anonymity. Explain to me how it happens that the person accused, when a whistleblower makes an accusation, can have the right that most Americans think they should have to confront those testifying against them. How is that accomplished?
So I'll speak to what we do. We get anonymous allegations frequently. We get people coming forward who are reporting misconduct who want to be anonymous, want to stay anonymous. So we get them both ways. We get people walking in saying, keep me anonymous, and anonymous complaints. We move forward on both if we think they're sufficient to move forward on and predicated and have support. But we then have to prove the allegations and get corroboration for it, because you're right, the individual, if there is a finding of misconduct, has a right to ultimately challenge the evidence found. But it doesn't necessarily mean that they get all the way back to where the nugget started if that information is corroborated through other means. And the IG Act requires us, actually, the law says, and Senator Grassley obviously has had a role in this, makes it quite clear. We are not, unless we're legally obligated to provide the information, the law requires us to do so. It's our obligation as IGs to keep that information.
Well, I appreciate that, because as you know, we may face that question here in the Senate relatively quickly. Last quick question, and I'm running out of time, so I just would like a quick answer if you could. I'm trying to find out who brought the Steele dossier to the attention of the FBI for the investigation? Was that Andrew McCabe or was that Bruce Orr?
So it was Steele in July 5th of 2016 going to his handling agent. The agent, there's a dispute whether he was a confidential source or not. We spend a number of pages on this. But the agent that Steele had a relationship with is the agent he went to with some of his reports. That agent then put it through a process at the FBI, and it then took from July 5th to September 19th to get the information to the Crossfire Hurricane team. Eventually, in that meandering over the, what is that, 2.5 months, there is information that we conclude in here that Mr. McCabe was involved in referring it over to the Crossfire Hurricane team.
All right, thank you.